Ladies and gentlemen, I'm Dr. Tashupalju Lecturer, Professor at Sikkim National Law University. It is my profound privilege to serve as the Master of Ceremony on this special occasion. On behalf of the Sikkim National Law University and the Sikkim Judicial Academy, I would like to warmly welcome you all to celebrate the Constitution Day, which is also known as the Samvidhan Divas. It is on this very day, 76 years ago, in 1949, the Constituent Assembly of India adopted the Constitution of India, which later came into force on 26th of January 1950. The Constitution of India is not just a collection of articles and schedules. It is the very soul of our nation, the foundation that binds us together despite the vast diversity in terms of our language, culture, and traditions. On this solemn day, we pay our heartfelt tribute to our founding fathers, visionaries like Dr. B.R. Ambedkar and the members of the Constituent Assembly, whose dedication, perseverance, and above all, their spirit of teamwork gifted us this magnificent constitution with a strong framework for the nation's progress. Despite numerous challenges, their commitment gave us the constitution that has withstood the test of time and continues to be the guiding light of our democracy. Now, it is my privilege to extend a warm welcome to our Chief Guest, Honorable Shri Justice Biswanath Somodar, Chief Justice, High Court of Sikkim and Chancellor, Sikkim National Law University. Your Lordship's presence inspires us and adds immense value to this occasion. We are truly grateful to have you amongst us today. We would also like to extend a warm welcome to our special guest, Professor Dr. Angotri Chakravarti, former head of the Department of Law, North Bengal University, former professor and registrar, West Bengal National University of Juridical Sciences, Kolkata, and former professor and dean, Gujarat National Law University, Gandhinagar, Gujarat. A warm welcome to you, madam. We are deeply honored to have amongst us the Honorable Vice Chancellor, Professor Achina Kundu Madam, Sikkim National Law University, Director, Sikkim Judicial Academy, Registrar, Sikkim National Law University, Mr. Binay Sharma, learned, respected principals, HODs, faculties of various colleges and universities, officers and staff of the entire judicial fraternity of Sikkim and Government of Sikkim, my dear colleagues and students, I would like to extend my warm wishes to all present here today. Your presence truly elevates the significance of this special occasion. We will begin today's program with the felicitation of our esteemed dignitaries. May I now invite Dr. Chuang Doji Lama, former principal of Sikkim Government Law College, Burtuk, and controller of examinations, Sikkim National Law University, to kindly present Khada and potted plant to our Chief Guest, Honorable Shri Justice Biswanath Somodar, Chief Justice, High Court of Sikkim, and Chancellor, Sikkim National Law University. Thank you very much, sir. May I now invite Honorable Vice Chancellor, Dr. Achina Kundu, Madam, Sikkim National Law University, to kindly present Khada and potted plant to a special guest, Professor Dr. Angotri Chakravarti. Thank you, Madam. To pay tribute to our founding fathers and to reaffirm our individual and collective commitment to uphold the noble values as enshrined in the preamble of our Constitution, let us now proceed to the collective reading of the preamble. I kindly request everyone to please rise for the recitation. I invite Deputy Director, Sikkim Judicial Academy, Ms. Jamyung Choden Madam, to kindly lead us in this solemn recitation.
We, the people of India, having solemnly resolved to constitute India into a sovereign, socialist, secular, democratic republic, and to secure to all its citizens justice, social, economic and political, liberty of thought expression, belief, faith and worship, equality of status and of opportunity, and to promote among them all fraternity, assuring the dignity of the individual and the unity and integrity of the nation. In our Constituent Assembly, this 26th day of November 1949, do hereby adopt, enact, and give to ourselves this Constitution. Thank you.
Thank you very much, Madam. I now most humbly invite Honorable Vice Chancellor, Professor Dr. Achina Kundu Madam, Sikkim National Law University, to kindly deliver the welcome address.
A very good morning to all of you present here today. As Sardar Vallabhbhai Patel had very rightly pointed out, a constitution is the backbone of a nation. It must be followed not in form alone, but also in spirit. I sincerely feel that our constitution is not just a charter of hope, but a journey from aspiration to action. Honorable Sri Vishwanath Shamadar, the Chief Justice, High Court of Sikkim, and also Honorable Chancellor of our very own Sikkim National Law University, Professor Dr. Gangotri Chakraborty, our special guest, Sri Binay Kumar Sharma, Learned Director, Sikkim Judicial Academy and Registrar, Sikkim National Law University, the Principal and Teachers of Sikkim Government Law College, Burtuk, my dear colleagues, my dear students, and all other distinguished guests present here today, ladies and gentlemen. It is my privilege to extend a warm and respectful welcome to all of you today on this momentous occasion of Constitution Day, a day that reminds us of the historic adoption of the Constitution of India on the 26th of November 1949. Today we stand not merely to commemorate an event in history, but also to celebrate a continuing legacy, a living, dynamic constitution that guides our democracy and shapes our collective aspirations. The values of justice, liberty, equality, and fraternity enshrined in the Constitution remain as relevant today as they were at the time of the framing of the document. Today we bow in homage to the wisdom of the framers of our Constitution, especially Dr. B.R. Ambedkar, the Chairman of the Drafting Committee of the Constitution, whose visionary leadership, commitment to social justice and constitutional morality continue to inspire scholars and citizens alike. It is my honor to extend a special welcome to our chief guest, Honorable Sri Vishwanath Shamadar, the Chief Justice, High Court of Sikkim, and Honorable Chancellor, Sikkim National Law University, whose presence greatly enriches today's program. It is a matter of great pride and deep honor for this university to have among us our Honorable Chancellor and the Honorable Chief Justice as our chief guest today. My Lord, your distinguished leadership in the judiciary and unwavering commitment to the rule of law stand as an inspiration to our academic community. We are truly privileged to welcome you on this significant occasion, and your presence greatly enriches today's deliberation. We deeply value your contribution to constitutional discourse, and we look forward to your reflections. As we all know, universities are the crucibles where ideas are tested, where young minds are trained to think critically, and where the future custodians of democracy are formed. Our role is not only to transmit knowledge, but to nurture values, to cultivate the habit of questioning respectfully, of defending the rule of law, and of serving the common good. When students learn the Constitution, they learn how power is constrained, rights are protected, and duties are defined. They learn how the promise of a just society becomes a practical reality through participation, deliberation, and respect for institutions. It is therefore especially fitting that we have invited Professor Dr. Gangotri Chakraborty, a teacher whose scholarship, integrity, and commitment to public life have inspired so many people, including me. Respected Madam, you have been my teacher and a teacher of many persons present here today. I think I was one of your first students. You were so young at the time when you had joined to teach us in North Bengal University. Madam, you have guided generations of students in understanding both the letter and the spirit of our Constitution. Your work has helped translate abstract principles into living practices, and your presence with us today is a reminder of the vital link between academic inquiry and civic responsibility. Madam, I must mention that your guidance has profoundly shaped my academic journey, and it is indeed a privilege to have you here with us today. Your presence is an inspiration to our university community, and I am honored to welcome you here, not merely as a guest, but as a guiding light whose teachings continue to influence my life and leadership. To my dear colleagues and students and all other guests present here today, Constitution Day is an occasion to reflect on your role as conscious citizens. The Constitution empowers you with rights, but it equally entrusts you with responsibilities to question, to engage, and to uphold democratic values in personal as well as in public life. I hope today's sessions ignite deeper constitutional awareness and inspire responsible leadership. At Sikkim National Law University, we remain committed to fostering a culture rooted in constitutional values, ethical governance, inclusivity, and academic integrity. May this day reaffirm our collective pledge to uphold the spirit of our Constitution in thought, action, and institutional practice. With these words, I once again welcome all of you with great respect and reverence. If the ideals of the Constitution are to live anywhere, they must live first in our classrooms, in our conversations, and more so in our conduct. Thank you very much. Jai Hind.
Much, Madam. Ladies and gentlemen, we now have the privilege to hear a special address from the Honorable Chief Justice, High Court of Sikkim and Chancellor Sikkim National Law University. May I now respectfully invite the Honorable Justice Sri Biswanath Somadar to kindly address the gathering.
Please sit down. Honorable Vice Chancellor, Sikkim National Law University, Learned Director, Sikkim Judicial Academy, Professor Dr. Chakravarti, Deputy Director, each one of you present in the auditorium, faculty members, students, other members in the audience. I wish you a very good morning. After listening to the erudite and profound disposition by the Honorable Vice Chancellor, and standing in the podium without any papers in my hand, I was wondering, I have some paucity of time, I have some commitment, how to speak to all of you, have a conversation rather, without notes. But then, maybe it's best to speak today on 26th November without notes because of a very simple reason. To me, the Constitution, and to every one of you, it should be not just a textbook or a document to read, but essentially to understand the philosophy and the spirit of the nation which is embedded in the various articles of the Constitution, without forgetting the preamble for which we all got up and recited. As students of law, how would you understand this philosophy? In my view, and in the view of some very eminent constitutional lawyers, this can be achieved when you do your academic exercise by looking into what is now very well documented, known as the constitutional debates. These constitutional debates were the culmination, which resulted in the culmination of the Constitution being adopted, were exchange of ideas of brilliant minds of yesteryears, whose understanding, whose thoughts, whose philosophy gave shape to this living document as described by the Honorable Vice Chancellor, the Constitution. If you really want to understand, apart from the drafting skills of the drafting committee headed by Dr. Ambedkar, if you really want to understand what ultimately gave shape to the preamble and the various articles, you do have to read and understand from the constitutional debates. As students of law, even after you obtain your degrees, your diplomas, your qualifications, whatever the university will give you, please remember that even today I consider myself a student trying to understand the Constitution. The other thing which I must take this opportunity to say, that as you keep reading the Constitution, you'll also start reading judgments. Here I must put in a caveat. The significant difference between the British legal system, which is also known as the Anglo-Saxon system, and the Indian legal system post 26 January 1950 is a migration from the common law regime to the statute law regime. The basic difference is common law evolved over the years through precedents and judgment laws, whereas statute or statutory law is no more judgment laws, but laws which are actually in black and white. It is only during interpreting those black and white areas, if there are some grey areas in between, we require some judicial interpretation, and for which we have to look at judgments. My fervent request to the students is never look at the judgment first. Look into the letters of the law. Look into the articles in the Constitution, which is the fountainhead for all laws. Look into the statutes that have come and see whether they are in sync with the Constitution. And then use your common sense and logic to see if there are grey areas, and only if there are grey areas, then only look at judgments. In other words, what I want to tell you is, do not become prisoners of precedents. Use your original mind and look at the Constitution and the laws flowing therefrom, and understand also from the objects and reasons. Just like the Constitution's objects and reasons are in the preamble, each statute law has its objects and reasons. Do read the objects and reasons, so you will understand what is the genesis of bringing a law into force. Never ever get saddled with judges making judgments. Each judgment is an authority for the proposition of law based on certain facts. If there is one little change of fact, the ratio of the judgment which you are referring to will not be applicable. I don't want to take much of your time. I just wanted to give you a fleeting understanding of how I have looked into the Constitution. I always looked into the articles, simpliciter, the laws that are coming there from simpliciter, looking at the statute, and try to understand what law will fit in the facts of the case that was before me, whether I was a lawyer or then as a judge. With these few words, I wish you a long day of deliberation, and as I would use the word conversation, because it is only through dialogue and conversation we evolve and get a little more enriched than ever before. Thank you very much.
We are truly honored by the gracious presence of the Honorable Chief Justice and thankful for His Lordship's inspiring special address that enriches this celebration. Ladies and gentlemen, with this, we come to the end of session 1.
Before we proceed with our second session, may I humbly request Dr. Chong Dorji Lama, former Principal of Sikkim Government Law College and Controller of Examination, Sikkim National Law University, to kindly present memento to our special guest, Professor Dr. Angutri Chakrabarti Madam. Thank you very much, sir. I now request Dr. Navin Sinha, Associate Professor, Sikkim National Law University, to kindly deliver the brief introduction of Professor Gangtok Chakrabarti Madam.
Good afternoon. Honorable Vice Chancellor, Sikkim National Law University, Professor Dr. Achina Kundu, Shri Professor Dr. Chuang Lama, COE, Sikkim National Law University, dignitaries, faculties and students of Burtuk, Sikkim Government Law College Burtuk, faculty and staff, Sikkim National Law University, staff members of Sikkim Judicial Academy, and my dear students. So, I have been asked to undertake this mammoth task of introducing someone whose reputation precedes the person herself. I have a profile with me which I'm afraid to say is longer than the introduction to my thesis. And being the humble person that sees, I'm very much sure that it's just the tip of the iceberg. As I stand here to introduce my mentor, my guru, I have this deep sense of, this profound sense of happiness. I feel honored, I feel privileged. I'm also slightly nervous. So I'm literally a mixed bag of emotions at this moment. Professor Gangutri personifies a lot of things. She is a distinguished academician. She is a profound thinker, a hardcore philosopher, an indefatigable social worker, a very committed teacher, but above all, I believe, she is a very compassionate person. So within the limited time that has been allotted to me, I'm going to selectively talk about the two facets of Professor Dr. Gangutri Chakraborty. Professor Dr. Gangutri Chakraborty, the academician, and Gangutri Madam, the person. Starting her academic career in the year 1986, Madam has served in various capacities across prominent universities in India. She was formerly the head of the Department of Law, University of North Bengal. She was formerly the professor and registrar, West Bengal National University of Juridical Sciences. She was formerly the professor and dean, Gujarat National Law University. Besides, Madam has also left an indelible mark as an efficient administrator. She has served as a member of the Committee for the Formation of Rules and Regulations, Kuch Bihar Panchananan Burman University. She is also an expert reviewer for CS Promotion, WBNUGS, and Assam University Silchar. She is also the member of the Selection Committee, Guwahati University, and Panchananan Burman University, Kuch Bihar. At different points in her career, Madam has been involved in some major and minor projects involving issues like sexual harassment, school dropout cases, Buddhist studies, and the likes. Madam is also a prolific writer, and she has many articles, monographs to her credits. This includes, but not limited to, the widely read book on law of maintenance. Besides, she has published a number of chapters, monographs, and articles in prestigious journals in India and globally. As a hardcore social worker that she is, Madam has been associated with several NGOs and has actively worked in the field of gender empowerment and children's rights. So until now I was talking about Professor Dr. Gangutri Chakraborty, the academician. I'd like to give a brief insight on Gangutri Madam, the person. And I speak from experience, and I think there are many others in the room who will echo my sentiments about the kind of person she is. She is by definition a very humble human being, but what defines her the most is a sense of compassion, is a sense of empathy. She puts a high premium on human values, and yours truly is one of the benefactors of that trait. I remember how she would take our lectures at 7:30 in the morning because she would be busy throughout the day with her administrative duties. She's a very welcoming person and I can vouch for that, either with a cup of tea or with a sound bit of advice, or sometimes with both. She's, in one sense, besides her godlike qualities, she's like many of us. She used to be fond of puchkas. I'm not sure whether she is anymore, interested in that thing or not. And over the years, I've been able to convince myself that it's not a coincidence that her name is Gangotri. To us, madam, you personify everything that is pure, beautiful and true. As I conclude my address, I see before me Professor Dr. Achina Kundu, the Vice Chancellor, Sikkim National Law University. I can see my senior, Professor Dr. Chong Lama, formerly Principal, Government Law College, Burtuk, presently the COE, SNLU. I can also see my junior, Rituraj Bawal. And there are many others in the room who have had the privilege to share, or the good fortune to share the space with you. And I think I speak for all of them when I say, ma'am, you have been absolutely instrumental in making us the person that we are. Thank you very much.
Sinha for the beautiful introduction. I now most humbly invite Professor Dr. Gangotri Chakravarti Madam to kindly address the gathering.
The Honorable Chief Justice of Sikkim High Court, Justice Vishwanath Shamadar, and the Chancellor of Sikkim National Law University in absentia, the Honorable Vice Chancellor of Sikkim National Law University, Madam Achina Kundu, the COE, Dr. Chong Dorji Lama, the learned director, Dr. Binoy Sharma, my student Naveen, and many others sitting in the audience, students of Sikkim National Law University, students of Sikkim Government Law College, students of Sikkim University, and all the honorable faculty present in this hall. I must say I am overwhelmed by the kind words that the Honorable Vice Chancellor and my student Naveen has been telling you about me. Please believe that much of it is very flowery and comes from their own kindness, but I'm truly privileged to be standing here to address this gathering on this special day, that is the 26th of November 2025. I almost said 1949, because this is extremely special, because we are carrying a legacy, and it is extremely special because the present generation has an obligation. After the Honorable Vice Chancellor persuaded me to come here, I had been thinking what would be the right topic to speak about. And I decided on this topic, the constitutional morality. But to put my presentation in the right perspective, if the Honorable Vice Chancellor allows me, I would like to start with a bit of jurisprudence and a story. All of you have read natural law, right? And all of you are aware that natural law has been, over several centuries, moral-centric. The disadvantage of a natural law being moral-centric was when the world started indulging in a number of secular activities like trade, business, traveling, settling abroad, etc. And also when the ruling powers were getting too powerful and exploitative, the intellectuals of that time asked the natural law jurists how would natural law respond to that situation. And as you know, they could not properly, notwithstanding what St. Thomas Aquinas was saying, notwithstanding what other jurists of that time said, like St. Augustine. The answer was not satisfactory. And you all are aware that in the Enlightenment era, a lot of things happened and we ended up having law posited to us, which is now known as positivism. But between this positivism, Enlightenment era and natural law progression, ladies and gentlemen, let me present two stories to you to put morality in the right perspective, of course. These stories are by the 17th century dramatist. It will also give you a link between the importance of literature and law. Goethe. He has written two dramas. One is Faust I and one is Faust II. The story of Faust I is that we see Faust as a Casanova, exploiting women, having fun, dining, wining, womanizing, and not being sincere towards any of these emotions. A young girl, a French lady, sincerely fell in love with Faust, but when she started to insist on her love, Faust said that he does not love her. So she went to her father and told about this betrayal. Those days, disputes would be settled by either a duel of swords or pistols. Now, Faust and this lady's father opted to fight with swords. Faust was a young man of late 20s, and this gentleman was a middle-aged man of late 50s. So naturally, Faust was faster and more agile, and he simply stabbed this gentleman with the sword and he died. Out of arrogance, Faust put his foot on his chest and said, come on, get up. Have dinner with me, you're my guest. But the person was dead. In the last scene of the drama, you see Faust is sitting all alone, frail, sick, and lonely. And he's thinking about his life. And he says, I wish there was someone with me to share my lonely dinner. At that point of time, there's a knock on the door, and the ghost of this girl's father is standing there, saying that, well, I'm here to share your lonely dinner. And during the dinner, this ghost asks Faust, what made you behave in this manner? And please note what Faust replied. Faust said, I was tired of morality. I was tired of distortion of morality. I was tired of the restrictions morality put on me. If I were to be born again, I would do the same thing to prove that good law and morals can even come from hell, not necessarily divine. So that was the contemporary feeling towards morals, that it is extremely restrictive, extremely, it limited human capacity, etc. So the lawmakers of the time, those who were talking about positing the law, they came up with the idea that law should be without morals. Law and morals will not go together. So we must have law without morals. And we come to the age which is now known as mercantile age, where it was only profit that mattered. Human values and other morality was of no significance. Profit was all. I don't know how many of you have seen the movie Mangal Pandey. There's a very telling dialogue in Mangal Pandey. A sepoy is asking Mangal Pandey, and I hope all of you can understand Hindi, यार ये कंपनी क्या होती है? And Mangal Pandey is replying, यार कंपनी वो चीज़ होती है जो हमारे बारे में नहीं सोचती, सिर्फ पैसों के बारे में सोचती है, इसीलिए तो ये अफीम बेचती है, नील उगाती है और सिर्फ पैसा गिनती है. That is exactly the picture of mercantile age. And a debate came up that law sans moral can be dangerous. It can be exploitative. And authors like Goethe at the end of his life, towards the end of his life, realized that this message that had very strongly come into the society, that law should be without moral, had actually damaged the society. Therefore he came up with another story, Faust II. Now in Faust II you see Faust is a young king. Again an arrogant self, he doesn't care for anybody. And he is walking through a valley where he sees a beautiful valley, and he says to his minister that I want this valley to be my capital. The minister agrees, obviously, the king's order. After a year, the minister invites the king and says, please come and see your capital, we have made it ready. Faust comes, he is charmed by the beauty of the place and the way the capital had been built. But in the far corner of the capital, there was this shanty-looking house and two old people who really didn't fit into the scene. So he called his prime minister and asked, why didn't you remove them? They are like a blotch on the moon. It doesn't look good. Remove them. So the Prime Minister said, sir, we tried. We tried very much. But this old lady and this old gentleman are too stubborn. They are not willing to vacate that place. So Faust said, bring them to me. I will talk to them. They were brought. Faust said, please vacate that land. The old lady and gentleman said, how can we? This is a place where our parents were married. We were married. Our children were born. We lived as a family. We grew up together. We taught our children what is good and what is bad. This is full of memories. This is full of our life events. We cannot abandon this. I said, I'll give you a penthouse flat. You all are old. I will give you n number of servants. I will give you all luxuries in life. But please vacate that place. These old couples said, what will we do with the penthouse flat? We don't want to look down upon the world. What will we do with all these servants who are only being exploited? We are very content and happy in our place. We will not give it up. First, angry and disappointed, decided that something has to be done. So he calls his Prime Minister and said, look, I don't care. Within a month, I want that place to be converted into a beautifully executed piece of scenario, aesthetics. The Prime Minister said, okay sir, it will be done. After a month, Faust was invited, please come and see your capital again. And lo and behold, on that land was a beautiful landscape. Fountains, lovely plants. So Faust was very happy. He said, how did you manage to do it? The Prime Minister said, well sir, it was your command. They wouldn't obey, so they had to be punished. So one night when they were sleeping, we simply burned them alive. Does it remind you that law is the command of the sovereign? And you have to get things done as the sovereign commands. And if the sovereign is arrogant, exploitative, then the law will also become arrogant and exploitative. This was a message where the judiciary, the lawyers, the thinkers, the juries began to rethink whether law should be without morals at all. Ladies and gentlemen, we still are debating. This debate whether law and morality should mix together still goes on. But yet, morality is very important. And from that point of view, my presentation is Constitutional Morality, the soul beyond the text. All of us read the preamble this morning. The seed of morality is in the preamble, but we, as students of law, must read between the lines and interpret the lines and the words in the proper perspective. This globalized world post-1990 has seen situations where the law has indeed been without any moral, and also it has seen situations where the law has inculcated morals within it. So, I start with my respect and homage to Dr. Bhim Rao Ambedkar, who said, constitutional morality is not a natural sentiment. It has to be cultivated. In other words, you can simply use the words of the Constitution without any emotions and morality and commitment and philosophy. But if you truly want the Constitution to be living, thriving, and an instrument with a soul, then your soul, your mind, your capacity of interpretation should look beyond the black letters of the text, read between the lines, and also reinterpret what our framers have been trying to tell us. The Constitution embodies moral and philosophical values. Constitutional morality bridges law and ethical governance. Philosophy is different. Ethics is different. Ethics is only a branch of philosophy. Philosophy is the umbrella. Philosophy will provide you with the mindset, and ethics will help you to translate that mindset into workability at the ground level. So it is ethics of governance. It ensures constitutional values prevail over societal pressures. Ladies and gentlemen, morality has many hues and tones. I am talking about the absolute universal morality as compared with the subjective morality which each one of you possess. The same thing will have different value in your personal lives. In your personal lives, the right and the wrong, do's and the don'ts will differ. What is my nectar will be your poison. But in universal morality, it's absolute and it is accepted by all. It ensures constitutional values prevail over societal moralities. So where there is distortion, constitutional values must prevail. For a moment, just think about the moralities that is propagated by the Khap Panchayats, by the honor killers, by the domestic violence people, by the traffickers. Those are societal moralities. Subjugation of women, the weak, is societal morality. Casteism is a societal morality, but not necessarily it is a moral, which is to be accepted within the framework of the Constitution. Not necessarily it is legal, because legality will speak about justice universally. But the justice that casteism, trafficking, exploitation brings about is not universal, not legal. Legal morality will always rule over societal morality. Here I am making a distinction of the moralities. This expression, constitutional morality, originated from George Grote's writing on Athenian democracy. It's a very interesting reading if you are interested in Cleopatra, Mark Antony, their love affairs, and how the Athenian democracy operated. It's a lovely historical novel, but it tells you a lot. And George Grote is looking at this system with the lens of our legality, where he says that the Athenian democracy lacked constitutional morality. And it caught on, this expression just caught on. It means adherence to the spirit and principles of the Constitution. What the king does and what the king ought to do. This is the natural law concept of is and ought. The positive law concept is the black letter of the law is, and there is no ought. But here you see what the king does is not the law. What the king ought to do is the law, because this ought is rooted in ethics and morality. Now, Ambedkar's vision was democracy in India needs cultivation of constitutional morality. He says, without it, democracy may fail despite legal structure, demands restraint, tolerance, and respect for diversity. We know that India is a country which is diverse in language, custom, religion, practice, in every respect. It is also a country still fraught with inequality. In that scenario, in that canvas, Dr. Ambedkar felt that there needs to be a conscious inculcation of constitutional morality. As students of law, all of you have heard Grundnorm, right? And you also realize that the Constitution is a reflection of the Grundnorm of the contemporary society which was there from 1935 onwards. It is the reflection of how the people of India wanted India to be. And one of the dominant morality, if I may say so, was that of nationalism. But that was not enough to handle the diversities of this country. Therefore, Dr. Ambedkar perforce had to point out that we need to consciously cultivate restraint, tolerance, and respect for diversity. I'm very sorry to say, standing in 2025, if you look at India's political scenario, it is lacking all these three factors. That is very unfortunate. That indeed is very unfortunate. Now, constitutionalism is a philosophy. You all know anything which ends with ISM and ism is a belief system. Constitutionalism is a belief system which tells you to honor and follow the spirit and letter of the Constitution. What then is constitutional morality? Constitutional morality, constitutionalism is talking about restricting power and legitimizing power. When power is not legitimated, power becomes exploitative. When power is legitimized, power becomes an authority. So constitutionalism is talking about creating authority by legitimizing power and drawing a Lakshman Rekha beyond which the authority is not supposed to travel. If I may use Bentham's language, it is the definition or the defining territory of lex populum and lex principum. Law given by the people to the authority to behave in certain way and bring about certain developments and progression of the country, and the law given by the authority to people in order to achieve the mandate that the people had given to him. So constitutionalism basically is an interplay of lex principum and lex populum. Constitutional morality is deeper than that. when you are using those limiting factors, drawing the Lakshman Lekha, trying to legitimize, you have to use certain ethical standards. And your standards must cut across the polity of India to accommodate all kinds of diversities in equalities, which we are yet to do post 1991. Dr. Manmohan Singh said that inequality is a structural difference and we will structurally correct it. That was in 1991. Ladies and gentlemen, standing at the end of 2025, I am yet to see the structural corrections. That has not happened. The result is we have not been inclusive. The haves have progressed. Have-nots are lagging behind. But our constitutional morality says no concentration of wealth in certain hands. Economic theory and economic governance should be such that there should be decentralization of economic power and a degree of economic achievement for every individual in the society. So we have so many schemes happening. But nonetheless, the have-nots have not progressed beyond a certain limit, and the haves have progressed beyond a certain limit. So we have to search for the soul of the Constitution. If you must truly believe that Constitution is a living document. A body without soul cannot be living. So you have to identify and see the soul of the Constitution and use the Constitution according to the consciousness of that soul, which is our collective consciousness. We are, and our consciousness, uninfluenced by any political hegemony, is the consciousness of the Constitution. So, while we are transforming this country and making it emerge as one of the important powers in the globalized world, it should be our commitment to see that the progression is not without ethics. Philosophical foundation of the Constitution we all read this morning. The foundation is justice, liberty, equality, fraternity. I call this absolute universal morality. I say that because I do not think anybody across the world or any governance will say that this is not important. There will not be a human being or a governing body which will say, well, we don't want equality, well, we don't want justice. So this is the core of the constitutional morality. Justice, liberty, equality, fraternity. These are anchored in human dignity and rational governance, and therefore rule of law becomes a predominant morality across the world. Any country which does not adopt the rule of law is actually living in Jungle Raj. So this becomes the foundational principle of the constitutional morality, derived from equality, justice, liberty, fraternity, etc. Now, it guides the institution in ethical exercise of power. Ladies and gentlemen, Article 21 is very dear to our heart, right? All of you remember Article 21?
Yes, ma'am.
No person shall be deprived of his life and personal liberty, the crux of it. There is a tail end. Except by the procedure established by law. Until Maneka Gandhi, except by procedure established by law, did not come into focus. If you look at the journey from A.K. Gopalan in 1950 to Maneka Gandhi in 1978, the graph goes like this. Yes, procedure established by law. No, command of the sovereign. Yes, procedure established by law. No, command of the sovereign. People like Soli Sorabji, Nani Palkiwala, they were all people who were in for command of the sovereign. But at the end, the command of the sovereign ended up having exploitative features. Therefore, in Maneka Gandhi, very rightly, the Supreme Court said, any law which is not according to the procedure established by law is not a law. Now, what is procedure established by law? The procedure established by law has three fundamental ingredients. Audi alterum partem. You have to give each party the right to defend one's position. Nemo judex in causa sua. The forum before which the person is defending himself or herself should be impartial. And third, reasoned decision. The judge cannot say simply, I sentence you to death. The judge has to analyze the evidence before him, rationally justify what he is going to do, and then sentence a person according to what the law says, not according to his whims and fancies. So today, ladies and gentlemen, the core of constitutional morality is focused in Article 21, the tail end, except according to procedure established by law. And that is not confined only to your courtrooms and lawmaking. It is confined to every administrative action. Even in your office, if you have to show cause somebody for doing something which was not desirable, you will have to give that person reasonable time to defend his case. Otherwise, if he goes to court and says, I did not have an opportunity to defend myself, the court will say your action is vitiated and is void ab initio. That deep has this morality gone. So today, more than no person shall be deprived of his life and personal liberty, what is important is except according to procedure established by law. Now, a little while ago I was talking about khap panchayat, trafficking and stuff. That is also a kind of morality, but not universal. It differs from region to region, person to person. I like to tell my students this is subjective morality. And I don't give any value to this morality. It's shifting like a shifting sand. Today it is one thing, tomorrow it is another. But constitutional morality is universal, ladies and gentlemen. It cuts across time, space, and people. It's applicable to all. And that morality makes sure that each one who calls himself an Indian citizen and those who have come into our country are not deprived of the essential fundamental rights. Article 14 says, no person, which means anybody who is in India, no person. And that is how universal this constitutional morality is. I have taken a few cases to discuss. You all remember until 2018, despite several debates, we had an invisible community. The community of LGBTQ++. They were ashamed of themselves. Section 377 of the erstwhile IPC made it punishable to have same-sex relationship. They were deprived of their human rights and dignity. They were deprived of jobs. They were treated as subhumans. For the first time, Navtej Singh Johor's case, they gained a degree of visibility. Now, public morality reflects the dominant social norms which may be based on prejudice, tradition, and majority of the opinion. As I speak, I am reminded of a judgment of the Guwahati High Court. I have, forgotten the name. I am becoming, as my grandson a little while ago told me, that you are becoming ancient. All these uncles and aunties are your students. You are ancient. So this ancient lady forgets names these days, citations. But a lady had broken her shakha and pola, the white bangle and the red bangle, the Assamese and Bengali women wear. Now if you look up the literature of Hindu law, you will see nowhere it is said that the woman has to perforce wear shakha and pola and put vermilion on the head. It is a custom. Maybe a custom having the force of law under Article 13. I wouldn't argue that. But this is custom and tradition. The Guwahati High Court gave it a legal recognition by saying that if a woman broke her shakha and pola and wiped away the vermilion, she had done cruelty to the husband. Because the husband believed that his life is linked with the bangles and the vermilion. Usko mita diya, to abhi hum mar jayenge. This is a custom and tradition, but not necessarily legally right. Now, unless our judges, lawyers, jurists are able to distinguish what is universally right and wrong, we will have judgments like this who will say, if a modern girl doesn't like to wear shakha and pola and put vermilion, she is reducing her husband's life and she is committing cruelty. Therefore, perception of constitutional legal morality is very important. And it should not be confined within public morality, which is governed by traditions, customs, and stuff like that. It should rather be rooted into the morality which we can strongly say is universal in nature. The constitutional morality, on the other hand, flows from core values of the Constitution: liberty, equality, dignity, and fraternity. If we put that judgment in proper perspective of constitutional morality, the judgment does not stand a chance. Why I am saying this? To tell you that it is not only the classroom, but the executors of the law, the framers of the law, must understand what exactly is constitutional morality. In Navtej Singh Johar, the court held that laws cannot be justified by public disapproval or majority sentiment, which the LGBTQ++ were facing. So how can it be justified? They had human rights. They had dignity. They had to be equal. They had to exercise liberty and fraternity. So Navtej Singh Johar is a watershed year. Emphasized the autonomy and dignity, constitutional morality over societal morality, affirmed pluralism as constitutional virtue. A recognition of the diversity of this country. Sabrimala, another interesting case. In Sabrimala case, the defense petitioner said that the Ayyappa Swami shrine should not be entered into by menstruating women. The majority of the judges said that this tradition, custom, is not according to customary morality. But ladies and gentlemen, the single woman in the judge said, after all, it is a custom from time immemorial. Should we not honor it? Again, the same thing. Grooming of the mind according to constitutional morality. The custom may have been from time immemorial, but it was discriminatory. As is discriminatory the discrimination against caste, class, gender, vulnerability groups like disabled, old age. But should the constitution morality not prevail? That which had to be condemned, for which we had to bring Article 15 and 16, read with Article 14, as the golden triangle of equality, should this triangle not put the custom in the proper perspective of constitutional morality? It is true that the majority of the judges said equality prevails. But it is also true that women must be taught and trained to understand the constitutional morality and rise above public morality. Joseph Shine. One of the most amusing statements that happened after Joseph Shine case was that Supreme Court has given permission to do adultery. No. The Supreme Court did not give you the permission to do adultery. The Supreme Court simply said, in a case of adultery, it is not only the men who are responsible, it is the female also. And there is unnecessary stigmatization by keeping the law relating to adultery within the criminal legal system. So let us bring it out into the civil legal system. But that does not mean that the Supreme Court has allowed adultery. But now that is the trend. The other day my scholar told me that her husband's boss told him, "Kya karte ho yaar, ek do girlfriend bana lo." So that has become the public morality now. Sorry, I think I made a mistake. NCT Delhi versus Union of India. Constitutional morality requires a commitment to the principles and values enshrined in the Constitution rather than, again, please note, rather than one's own political ideology or institutional ego. Rather than one's own political ideology or institutional ego. So students of law, if they join the politics, it would be good. You will be elbowing out some of the irrational things that is happening. But those who are not joining the politics, ladies and gentlemen and students, we are privileged. We can criticize any wrong thing that is happening in the society, whether it is by the Chief Justice of India or by a local politician. We have the right to express our opinion. So please feel proud of that black coat you are wearing. And please keep your backbone straight to be able to say what is wrong and what is right is right. Now the judicial role is very important, and I was very happy to hear Justice Shamadar say that read the judgment last. I wouldn't say read the judgment last, but I would say read the judgment simultaneously as you analyze the legal provision. And thereby you will be able to understand the awareness and sensitivity of the judge who is passing the judgment. Constitutional morality, therefore, must be included in your interpretation of statutes. All of you have read interpretation of statutes or might be reading soon. All this golden rule and harmonious construction and etc. must be imbued in constitutional morality. It is not arbitrary. It is not devoid of this morality. And that raises a debate on judicial activism, which also is sometimes judicial overreach. In the zeal of being active and correcting the society, there are times when the judiciary has not honored the separation of power theory and overstepped its boundary. So Ambedkar's warning when we are talking about constitutional morality, that morality must be internalized. It should be in your day-to-day life. It should be in your domestic life. It should be as you treat your parents, as your children, your teachers, your colleagues, your peer group. Constitutional morality should be inside you. Legal form without ethics is hollow. The Constitution is only as good as those who live it. We can change it, we can distort it, we can do anything because we are more powerful than the black letter of the law. But think twice before you change that black letter of the law. So, ethical core of governance is integrity in office. These days, youngsters like my grandson laugh when we say honesty is the best policy. One child once told me, then you are going to be poor for all your life because honesty will not make you rich. And that child was 7-year-old. So that reasonable, invisible, reasonable man is tuning the mind of the child. I remember another child telling me, you remember that Aesop fable, the boy kept calling wolf and ultimately he ended up being eaten by the wolf because nobody believed him. So this child told me that boy was foolish. He should have kept on saying that the wolf is fiction, then others would have helped him. Center for Public Interest Litigation Union of India, which is also known as 2G Spectrum case, held the court quashed the arbitrary allocation of 2G Spectrum license, holding it violated the principle of integrity and transparency in public administration. The judgment reaffirmed that public offices are positions of trust and the exercise of power must be guided by constitutional morality, transparency. I have quoted the judgment saying, public officials are trustees of the constitutional powers vested in them. Such powers must be exercised in a manner that upholds public interest, integrity, and fairness. The significance of this judgment is integrity in office equals to adherence to constitutional principles, fairness in decision making, and avoidance of arbitrariness and corruption. In Vineet Narayan versus Union of India, which is also popularly known as Jain Hawala case, the court emphasized that lack of integrity in governance erodes the faith of the citizen in constitutional institutions. It directed the establishment of mechanisms like Central Vigilance Commission and to ensure independent and honest investigation into corruption by high society. Significance, it reinforced that integrity in office is a constitutional expectation. In Manohar Joshi versus State of Maharashtra, the court held that the public office is a public trust and misuse of office for personal political gains is breach of that trust. In BP Singhal versus Union of India, the court held that arbitrary removal of appointment of governors violates constitutional morality and integrity of office, emphasized that constitutional offices must not be politicized. Now, what is the impact of constitutional morality? It protects dissenting voice. So you have right to say no or I don't agree. It promotes non-discrimination and it promotes empathy for the marginalized. The challenges are the political populism that you see these days, the institutional erosion. If you look at the political arena, no constitutional head is respected. Of late, the constitutional head of Election Commission has been bashed left, right and center with or without any logic. Governors are being abused and accused of many things. That is also not permitted under constitutional morality. Misuse of constitutional symbols, we often do that. So the reason is, or the challenge is, weak constitutional literacy. And I felt very happy when I was told that the specialization in the Sikkim National Law University, one of the specialization is Constitution. I think this is of paramount significance because as each one of you pass out, each one of you must spread that message to another n number of people, and the society must become constitutionally aware. So, role of the citizens is to uphold constitutional ethics and promote civic education and literacy. So, the comparative perspective in US what is called constitutional patriotism. Anything that goes against this is illegal. In South Africa, this is transformative constitutionalism because South Africa very recently came out of the apartheid and it drafted a constitution taking much of the ideas from Indian constitution, but there is this transformative constitutionalism, which is very interesting because it kind of reconciles the earlier apartheid discriminations and the present non-discriminatory policies. And in India, it is a blend of legality, ethics, and social justice. So transformative justice is that where you have moral force behind social reforms and a living constitution that evolves with the society. Ladies and gentlemen, in this context, let me remind you that we have transitioned from socialist pattern of the government to a globalized, privatized pattern without a single amendment to the constitution. So that is transition. The popular mindset which helps us to transform ourselves from a state-controlled economy to a market-driven economy without a single amendment to the Constitution of India. So future relevance is to fit in the digital rights within this constitutional framework. The digital virtual world is something we are beginning to grapple with. Environmental constitutionalism is very important. I have been telling over the years that the way you are violating the nature will hit you back one day. And this year we have had 3 cloudbursts and our own Mirik is half washed away. We have had the Gurdumar explosion which created havoc in state of Sikkim and Lower Tista. So constitutionalism also must include environmentalism. So intersectional justice is another important area where it should be inclusive. It should look at all the communities we have left behind. So in conclusion, ladies and gentlemen, constitutional morality is the soul of the Constitution beyond the black letter of the Constitution. It bridges the gap between law and ethics, notwithstanding the debate whether law should have morality in it or not. And it preserves, ensures justice and fraternity, which includes dignity of human being. Justice Vivian Bose once said, the Constitution is not a mere lawyer's document. It is a vehicle of life. I have taken references from these documents. Thank you very much.
Thank you, respected Madam, for your enlightening presentation on constitutional morality. Ladies and gentlemen, Professor Dr. Angotri Chakravarti Madam has kindly agreed to engage in a discussion with the audience. If you wish to ask questions, please introduce yourself briefly and keep your questions concise in the interest of time.
A question from a very apolitical perspective when I dwell into part 1 of the Constitution and right now the renaming emergency, as I would like to call. Does such colorable exercise of Article 3 today constitute a renaming emergency that erodes federalism and secularism as dangerously as the 1975 national emergency eroded fundamental rights and democracy?
I don't think so, Beta. The issue is today, 1975 democracy, as you please sit down. 75 democracy was a particular powerful entity trying to capture the power of governance in India vis-a-vis those who were opposing to autocratic unilateral governance. That was a different issue. Today's issue is two. We have only limited resources, limited land, limited water. Our population is growing. If we allow illegal migrants into the country, then these resources are being taken away by persons who are not Indians. India belongs to Indians. So that is one issue of grave concern. But that also means that the process of refoulement of these illegal immigrants should not be violative of procedure established by law. So I don't think there is a parallel. This is rather a national crisis where the demographic scene is changing. And I'm not saying that we should have a Hitlerian point of view that only Aryans must be there or only that race or this race must be there. I'm simply saying that if you come into my country is catering to your need by depriving some of the citizens of my own country. Another question is, if you push your citizens in my country, who bears the cost of it? The pushing country should bear some cost of it. But that's not happening. So India's economy is again oppressed.
Excuse me, I'm so sorry ma'am to interrupt. What I meant is like in India's constitution it's supreme and political parties, they are not rigid because democracy, the right to vote and political parties, they can come, they can go. But right now to use in their political manifestos before election that will rename this locality, from this to this. Ma'am, won't it be very violative because tomorrow another political party may come and like we'll have trouble knowing the name of our own region because today it might be Ahmedabad, tomorrow it might be Ramnagar, after that Jesuspur. So ma'am, my question is...
The point is when this election manifesto comes to you, the political parties are asking for your support to that manifesto, right? So if all of us together don't like that manifesto, we don't make that political party win. The ultimate power is in our hand. That is why we, the people of India, gave to ourselves this constitution. Yes. Please.
Actually, what I want to add on is, first of all, what happens is, the democracy in our country itself is faulty compared to the US one. Because the first past the post itself, first of all, we are depriving a lot of people to vote who are under 18. Right, ma'am? Because democracy means majority here. Majority in the faulty sense, like first past the post. Whoever gets first past the post is the winner. So here what I say, when you talk about the constitution and the equality, is first of all below 18. I'm not saying it is not justified to let people below the age of 18 not to vote. But I'm just saying from the point of from the point of morality also, is that next is what happens is, out of the voters also, if there is around 70% voting, or let's say on the upper side of 60% voting, still they say it's a good voting pattern. So that way also a lot of things, and we are influenced by a lot of baggage from our olden days. We have been through a lot of invasions. We have the religion background itself may not be with the times. So there are a lot of things we can concur upon, and the effects of it also. And I might not be able to, I'm quite rusty now. But anyway, what I want to, the theme of ma'am's presentation is so it's different from what I've said earlier regarding the faulty democracy, is that the general comment I want to make, with your permission and the House's permission, is that I would like to motivate, encourage, or rather support that we have to follow the holiness, the Dalai Lama's saying, or rather it is, attached to his saying that right is right even if nobody is doing it. Wrong is wrong even if everybody is doing it. Thank you very much.
One more question.
First of all, thank you so much for the insightful session on constitutional morality and constitutionalism and various aspects of constitutional morality. So I want to know about your opinion that what if we let every time constitutional morality prevail over the societal morality, then what's your, according to you, what do you think, don't you think that we would have a society governed by judges, social norms decided by jurists, and we lose the very essence of societal fabrics which binds us? And what do you think, doesn't it come under the judicial overreach? Because there may be a custom which is very discriminatory, I'm not talking about that, but there may be a case which binds the social fabric, and if we lose that essence, it would create a havoc in the society.
Like the Sabrimala case? Is that are you pointing at?
I am pointing out Sabrimala case and another, the same-sex marriage, the Supriyo versus Union of India.
That's a Supriyo versus Union of India. What is constitutional morality at the end of the day? At the end of the day, it preserves human dignity and integrity. It makes a human being accountable, and also it latches onto equality, justice, etc. Now, I personally feel that societal norms, if you look at Article 13 of the Constitution, it says even any custom or customary usage that violates the fundamental right or the constitutional morality is void ab initio. So all societal morality may not be violating the dignity of human being and violating the constitutional morality. Therefore, I would not say that those customary or public morality is wrong, and they should define the society. But those practices such as khap panchayat, such as honor killing, such as subjugating a woman to certain practices which are indignified for her, those practices certainly are not good for the society, and they are certainly violating the constitutional morality. Therefore, they should go. That will not affect the societal fabric. Now, any practice which is in existence and has not been brought before the judiciary and is discriminatory in nature remains like that unless it is challenged. Therefore, these negative things are there in the society and will continue to be there in the society. That's one part of your question. The other part of the question is whether the judiciary, all the decisions will be made by the judges and the judiciary. Now, it is not necessary that all judgments are accepted by the nation. Many of the judgments are corrected by legislature as well, on the popular demand. Therefore, judges do not have an exclusive right to define the law and dump it on our head. We still have a Godavarman case going on, which is a clear case of judicial overreach. Judiciary is taken on the power of the forest department and is looking after the Indian forest by itself. And still the case is still open, the final judgment has not come. Now, we can call that judicial overreach, definitely. But what if the concerned department is not functioning? What if the forest department is not functioning and selling away all the timber from India? Who accounts for the climate change? Who accounts for the soil erosion? Who accounts for the resulting feminization of the agriculture? So there are issues which cannot be defined as yes or no. It has to be very strongly contextualized and analyzed accordingly. Did I answer your question?
Actually, I was asking about the constitutional morality which actually try to shook the basic foundation of the society. For example, in the Sabrimala case, there are peoples who have certain beliefs, and what if they hurt by these constitutional?
Those people who believe they should not go to the Sabrimala shrine, they are free not to go. Judiciary is not forcing them. But if a menstruating woman feels that she wants to go, you cannot stop her. That is individual choice. If I feel I am a menstruating woman, I will not go to Sabrimala, well, that is my individual choice, my individual morality. But the universal morality is you and I are equal. So when you are going as your wife or sister, if I say I want to come along, the law cannot stop me. That would be discriminatory, right? So it doesn't change the social fabric. It merely puts the right of choice in your hand, saying that there is a greater canvas which is just, fair and equitable, and here is your personal belief. If you believe you don't want to go, don't go. I will not force you. But if you want to go, I will not say law does not allow you. I will not allow the so-called leaders of the religion to have a hegemony over my right and my dignity. That's the point.
So, some kind of balanced constitutional morality with the societal norms.
It always happens better. It always happens. But it's a matter of choice.
Thank you so much for clearing my doubt.
Yeah, there is Naveen.
Yes, ma'am, sure.
To ask.
We ultimately decoded based on individual perception, individual interpretation. I mean, these have to be decoded by judges, jurists, lawyers, legislators. So at times I believe there is this disconnect, between what you just referred to as something as universal morality, and whether you want it or not, when we are interpreting it, that subjective morality creeps in, whether we want it or not. So how do you reconcile with these two extremes?
Naveen, what I was trying to say was, conceptually these are universal and absolute. But content-wise, it may vary. Content-wise, affirmative action, positive discrimination, is a subjective constitutional morality, right? It may not be applicable in USA or South Africa or Germany, Europe, anywhere. But it is applicable in India. But the concept of equality, the concept of justice is universal and absolute, because every individual across societies, across space-time will want equality, will want justice to happen, will want that the person's dignity be preserved. But content-wise, as you said, the regional morality or individual morality will come in. So content-wise, it is not absolute. Concept-wise, it is absolute.
Thank you, ma'am. Thank you.
Curious with this particular principle called the basic structure doctrine. And I've always been curious with this doctrine, this particular. Well, I suppose it's the ultimate safeguard to the vicious amendment of the Constitution and losing the Constitution altogether. Ma'am, my question is, was there any implied form of this feature in the Constitution before this came up formally in Kesananda Bharati case?
Very interesting question actually. Kesavananda Bharati, if you have read the entire judgment, it is more than 1,000 pages. Nowhere have the judges have used the word basic structure. It is a later put on expression. Now, just while talking, I was saying there is a grundnorm which approves the way the Constitution is framed and the way it is functioning. In other words, it is the people's collective wisdom, which I called a transcendental metaphysical wisdom, which defines the Constitution and our nation as a whole. Now, basic structure, according to me personally, is very akin to that. Now, if you look at the constitutional layout, the basic structure is this, that we have a titular head, we have a governor, we have separation of power, we have rule of law, we have several doctrines coming into operations. These are all there to stay, to uphold the spirit of the Constitution. So any amendment which takes away the spirit of the Constitution, let us say tomorrow there is a judgment which says the post of the president or the post of the governor is no longer required. Or let us say in the current controversy, the post of the election commission is no longer required. Does it not hit at the basic structure? Does it not hit at the root of the Constitution? So that is the basic structure. It is not limited to whether you want to amend fundamental right or whether you want to amend the preamble, or it depends on what you want to amend and what consequences it will lead to. Today, can we have an amendment saying we don't want a president, we don't want a governor because they are causing too much of controversy and they are very expensive? Can the Constitution survive in that case? Can we do it? We cannot. That is the basic structure, which will change the whole fabric of India's governance.
Thank you, ma'am. I have another similar question. This is with regard to the procedure established by law. The interpretation that we currently have was given in the case of Maneka Gandhi, I believe. And a lot of us believe that it was the adoption of American due process. And my question is, ma'am, why do we need it to adopt this American due process when we already had safeguard under Article 13?
We did not adopt the American due process. That's a wrong presentation actually. What we did was we focused on the importance the American constitutional experts gave on due process. For them, due process was very important. And until Maneka Gandhi, for us it wasn't so important. We did not say that procedure established by law should be replaced by due process. We merely said that procedure established by law must be as important and as relevant as the due process, as in America. That's it.
Thank you, ma'am. One last question, if I may. Ma'am, what is the relevance of Constituent Assembly debates as an authoritative tool to the interpretation of Constitution?
The relevance is in the Constitution Assembly debate, a lot of subjective ideas and subjective opinions were given, and which ultimately on majority opinion either won or lost. And from there we developed the present Constitution. I'm not saying that we should stick to that route and be static. What I'm saying is that provides an insight into how the Constitution should be functioning, and if we want to change that, we should have proper reason to overrule that. Reasoning to overrule that old opinion that they had. In fact, if you ask me, I have n number of opinions which I want to overrule, but then I am not a constitution maker.
Hello. Due to the paucity of time, we will just have one more question. I request all students to please keep your questions precise.
Actually, there was a thing that was running in my head since a long time, so I really wanted to know. Ma'am, my question is, does the police practice of misusing powers, such as fabricating case diaries and subjecting individuals to prolonged mental torture, ma'am, even after acquittal, amounts to the violation of constitutional morality? Ma'am, what do you think on this?
It definitely violates constitutional morality without a question. Unfortunately, we are still carrying the colonial legacy where police is concerned. But after D.K. Basu, the procedural laws have undergone a lot of changes, amendments, and we are trying to be more reasonable, more conscientious on arrest and acquittals, but nonetheless, our police force is still rooted in the colonial legacy. So things do happen which should not happen.
Yes, ma'am, this thing is like still in practice, as I've even seen from my personal experience as well.
Yes, exactly. My tomorrow's presentation in my own university is on that, how we are carrying the colonial legacies and how we are obligated to change them. Yeah, it should happen.
Thank you so much.
All right, thank you. With this, we come to the end of the question.
Sorry to interrupt you, sir, but can I ask you one question, ma'am, if you don't mind, with respect?
This is the last. Sure.
Thank you, ma'am, for allowing me. Ma'am, you taught me today the soul of the Constitution beyond this text. So my question is that if sovereignty in India lies beyond the constitutional text, how do we identify its source? People, court, or unwritten constitution ethos?
People.
Ma'am, then, in order to that, respected to that, in your opinion, recent Supreme Court order on relocation of stray dogs matters. It doesn't matter with the people, ma'am, as far, and I need your opinion regarding that matter.
I could not get Supreme Court's opinion on?
Relocated on the stray dogs. Stray dogs.
Stray dogs.
Stray dogs.
Yeah, what's the problem with that?
Ma'am, you say that a soul belong only for the people of the India, and then dogs doesn't matter. Doesn't concern with the people. So why the judges making a laws according to them in order to without direction? They doesn't mention the without direction to where the relocation happen.
You are an Indian, right?
Yes, ma'am, I am, ma'am.
What's your religion?
Ma'am, Hindu, ma'am, by birth.
By birth.
Yeah.
You know, there is a saying among the Hindus, Sarva Bhute Narayan.
Yes, ma'am.
So every element, whether sentient and non-sentient, represents God. So the animal, as the humans, represent God. Okay, that's a moral teaching. Do you think it's wrong?
I think dogs doesn't have a voice to make.
So does that mean the constitutional morality only protects the voice? Those who have voice, does not protect the voiceless?
Yeah, in that judgment, I hope so, ma'am.
No, it only said relocate them so that they can survive. Relocate them so that they can be looked after. It did not say relocate them as a discriminatory measure. It did not say kill them. It only said castrate them so that the population can be controlled. So there's a lot of morality, if I may say so, goes into the judgment.
Yeah, ma'am. There is a Maneka Gandhi. They gave a reasonable procedure established by law, but in this matter, there is a no reasonable procedure established by law, according to the Maneka Gandhi, which we related.
I'm sorry, you're misquoting. Maneka Gandhi didn't say reasonable procedure established by law. The Maneka Gandhi judgment said the judge must give a reasoned decision. So when the judge is writing a judgment, he should give a reasoned decision, not reason established by law. There is no reason established by law.
Thank you, ma'am.
All right. Last question. Thank you very much, madam, for your patience, for your gracious and articulate responses. May I now most respectfully call upon Mr. Binay Sharma, Director, Sikkim Judicial Academy and Registrar, Sikkim National Law University, to propose the vote of thanks.
Good afternoon, everyone, ladies and gentlemen. Honorable Vice Chancellor, Sikkim National Law University, Professor Dr. Gangotri Chakrabarti, our resource person for today, the professors of the Sikkim National Law University, the Law College, in whatever rank, assistant professor, associate professor, the faculty members, students. Since we have with us, this is a very academic program, so, and we have with us my teacher when I was in law college for the LLB or LLM, and many known faces here. So I propose this vote of thanks not in a very formalistic way. And even being as a registrar of SNLU and as well as director of this academy, I take this opportunity to be a little liberal and not be formalistic on this vote of thanks. First of all, I would like to thank Honorable Vice Chancellor Dr. China Kundu for conceiving this program as a joint collaboration with Sikkim Judicial Academy. To be honest, the Sikkim Judiciary, as far as I know, including the Academy, has not celebrated Constitution Day till date. This is, as far as I know, the first Constitution Day celebration by the Judiciary or the Academy in Sikkim. We often see the government departments, in fact, they have this compulsory attendance on 26 November where they recite the preamble. But this program was more than a formalistic one, and we had a very good discussion. First of all, what is heartening to see here is, students posing questions. The very essence of law is being critical. If we, as the Honorable Chief Justice put, in the morning don't be prisoners of precedents, and the very presentation of Madam goes to the core of the Constitution, where we cannot just stick with the text. We have to go beyond it if we want to really do something with the knowledge we have in law. So the last person who did not get the chance to ask the question, don't be disheartened. Many such programs will be there because we need to take care of time also. And one of the thing in law that always bothered me when I was in college was the morality and the law. Both are there in the society. Law has its own source, morality has its own source. I always searched for the answer as to where these two culminate or where these two separate. Still the real answer I'm still looking for. But in my personal view, one fine day it just came to my mind that once the morality becomes a law, it's no longer a morality. Law, it becomes a law, and we have to see it from the viewpoint of law. Because law has its own implementation procedure and consequences. Morality may not have. So that's my view on it. And one of the things that struck me from the madam, it was very nostalgic for me. I felt like I was in the classroom, LLM classroom we used to have in madam's chamber only. And madam used to say, I used to question a lot because the theory of Austin always seemed practical to me. Later on I realized that it's not the everything, because when you come into the real world, it seems the law is the command of the sovereign. It took me a lot of time to understand the other theories because I was obsessed with Austin's theory and I was in that particular line. And madam would say to me, this batch also has one more Austin, and every time I have one Austin in my classroom. So that was a learning process. Another thing Madam put out was the consciousness. The consciousness of what law we have is very essential to develop in the legal field. It varies as we move forward. If you are a lawyer, you will certainly be having a certain perspective. The case becomes very important to you, the client's case and your interpretation. The court would look into the law and justice more than the lawyer. So the court would be more inclined towards doing justice, being fair, and would have its own interpretation. As an academician, the core lies in teaching the truth that the law says. So the lawyer, the judge, and the academic side may differ in the way that laws are meant to be or what it should be. But the ultimate point is that with the justice, all laws are meant to do justice. So there we differ a bit. And one student was talking about Sabarimala case. That case is very essential to our constitution, and it's still not closed. The other legal question has been referred to a larger bench, and its outcome may still change the decision in the Sabarimala case. Though I do not agree with the procedure that was adopted to refer this to a larger bench as a judge, but it's there in the larger bench to determine a larger question on the freedom of religion. So that because there was a lot of criticism for the Sabarimala judgment, especially from the public and the ones who thought that the custom must be protected. But what we lose sight is, the Constitution also contains that we should develop scientific temper. And according to me, this judgment is absolutely scientific and reasonable. Because it only stops a certain category of women from entering the temple. We have classified that class, the menstruating women, which is absolutely discriminatory. So the person who ever asked about the sentiments, I think sentiments must give away when we are governed by constitution, and it becomes discriminatory, no matter how hurtful the sentiment may be. That's the job of the judiciary. We cannot, give the sentiments priority if there is a discrimination being taken place. Why only certain category of women should be stopped? Menstruation is absolutely scientific. It's a natural cause. And if we stop women entering the temple because they are menstruating, no matter what the custom is, then we are discriminating them on account of their body, their physical, their makeup. Can we discriminate anyone based on their physical, natural happenings? So I think there's nothing to balance in this case. The facts are absolutely discriminatory from my point of view, and the judgment as well says that. The dissent was based on a very technical ground that this petition cannot be entertained as a PIL. Another thing that made me nostalgic was when someone asked about his particular question was, if this procedure established by law is for persons, humans, what about the animals? When the relocation was ordered by the Delhi High Court, Supreme Court, I think he was meaning, does this procedure established by law also take into account the animals? Now, whether coincidentally or not, my first research, it was actually a step towards writing dissertation. In the part 1, we had to do some kind of research. My topic was rights of animals. And as I moved on, I had to struggle whether animals have rights in the real sense that we have in the Constitution or in any other law, except from the law against the cruelty of animals. So, do we have rights for animals as we humans have? That it may not be as much as the rights that humans have. Animals may not have that rights. It's not that they don't have, but we have not recognized that to that extent. Because whatever it is, the laws are made by humans, the society is of humans. That's the perspective that has been so far. But I appreciate all of your very critical thinking, and so you can move ahead and prove that animals do have rights as much as we have. So that were the insights that I got. I thank Professor Dr. Gangotri Chakrabarti for traveling so far from Siliguri and here, and despite hectic schedule, and Madam would be returning today. I hope your journey, the program here, your stay has been very comfortable, ma'am. We hope to see you again, and we also request you at least take 2-3 days so that we can take you around to places where in this particular season the sun is shining and it's not very cold also. So we could have taken you around and shown some good places here. Nevertheless, ma'am can always come again, and we will be inviting ma'am, as you are such a resourceful person that we need someone who would be of immense help to the students here who seem to be critical. Yes, ma'am. And I also thank the Sikkim Government Law College for their participation here. And despite today being a Wednesday, I believe, we all have been here. There might have been classes, and thank you very much for your attendance. I also thank the students who have been a part of this program for your attendance. Of course, you should attend, but still thank for your presence. I thank the team of the Sikkim Judicial Academy and as well as the Sikkim National Law University for making this event a success. I was worried I had gone to a place where there were no networks, etc. It was Gurudongmar, Dongkela and all. I had to accompany Chief Justice in his tour. So for almost one whole day I had no networks. I came back yesterday and talked with my subordinates, and these things worked out. Thank you all who have been patient to me for me directing through phone and WhatsApp to do this and do that so that this program becomes a success. I thank all of you. We hope to have a similar program again, and from heart and on behalf of Sikkim National University and Sikkim Judicial Academy, I once again thank Professor Dr. Gangotri Chakrabarti for her benign presence today. Thank you very much, everyone.
Thank you, everyone. With this, we conclude today's program. Thank you all for your gracious presence. I wish you all a pleasant afternoon. Namaste and Jai Hind.